Now, then the next part is where you start going, well, with what happens though when somebody is being unreasonable
Yeah,
or deliberately going out of their way to not cooperate and make life difficult for the other party.
right.
Under sub rule 24 sub 4, again, the court can set aside a presumption if the behavior of the successful party is considered unreasonable. So if you've tried to bully and steamroller the other side, even though you are the successful party, you end up with an order more in line with what you've been asking for than what the other side is asking for. If a court finds that you've been unreasonable, even though you're successful, the court can deprive that party of their costs and even order them to pay the other side's costs, even though they were the successful party. Now, you don't see that happen very often. And one of the things I meant to do to get ready for this is to find, because I know there are the cases out there where that in fact has happened, but they're one-offs. They're really, really rare, and they're really fun to read, and they're really interesting, but not really something that happens a lot. So we're not going to waste any more time with that. Make sense?
Yeah.
Okay, so we've talked about what is reasonable or unreasonable behavior, because as soon as you start looking at a party that's behaving unreasonably, then the whole issue of costs starts rumbling around. So what exactly does a court look at to figure out if somebody's being unreasonable or not? So what the court is ordered to do under 24.5 is they have to consider and examine the party's behavior regarding issues from the time they were raised, including whether or not an offer to settle was made, whether any offer that was made is actually a reasonable offer, and is there any offer to settle that the party either withdrew or received from the other side and didn't accept it. So again, going back to that basic presumption that parties are supposed to try to resolve matters wherever possible without taking up the court's time, if it's a reasonable solution. So again, where the rules go into it is saying what is unreasonable. So one of the most surefire ways to have costs awarded against you if you show up to court unprepared, if you don't show up at all for scheduled court appearance, or if you act in bad faith. Okay, again, everybody knows, and especially if you're a self-represented litigant trying to do this on your own and running into the rules for the first time and the requirements for the documentation and the serving rules and for what it takes to upload matters to the court or whatever. It does take a considerable amount of money and preparation time for any court appearance. And judges are very, very well aware of that, and they will not look favorably on a party who does not use their time to prepare for a case or totally ignores their obligation to the court, especially for the things that are set out in the family law rules for what they must do. It's a statutory obligation to do things. If you are a litigant who just ignores what the rules say and what you're supposed to do, and you just don't do it, you are likely looking at an order for costs against you at some stage in the process, especially if the other side has a lawyer and is aware of the fact that they can be asking for costs at every stage of the proceeding. So what can happen is under Rule 24.7, if a party fails to attend court or isn't sufficiently prepared to participate in whatever the hearing is, like let's say it's a case conference or it's a motion, Rule 24 sub 7 creates a presumption that the unprepared or absent party will pay the other side's costs. However, the courts still have a discretion to determine whether it's in the interests of justice to award costs or not. So one of the issues that comes up quite often is, what do you do when you've got an impecunious or broke unreasonable party? Again, you're going to find that there are a lot of cases out there that there are people that just because they figure they're self-represented and they're on social assistance or they have no money or they're on legal aid, they figure they can keep dragging the other party into court anytime they want and there can't be any consequences because they're saying, what judge is going to make an order for costs against me? I have no money. I'm impecunious. I have no ability to pay an order for costs. Generally, the courts say, doesn't happen. Whether a party has the ability to pay costs or not is a factor for the court to consider when they're being asked to make an order for costs against that party, but it's not the overriding consideration. That you can't just say, well, I know I lost this case badly and I know I did it because I was being unreasonable and I behaved badly, but I'm on welfare. Like, you can't make an order for costs against me because I have no ability to pay. Guess what? The courts will likely still make an order for costs. Like I said, just being broke and not having an ability to pay does not protect you. Because again, the whole point of the rule is to try to get people to resolve matters. If somebody figures they can shield themselves from a cost award simply because they have no ability to pay a cost award, it's not necessarily going to work out in their favor. And there have been many, many cases where the person has tried to argue that they don't have the ability to pay costs, so the court should make that order. And always what the case law says, that ability to pay a cost order is something to be considered, but it is not the overriding or governing factor. Yes, ma'am.
That's a really good point that you mentioned, because I have a question now. Because if someone truly, I mean, they have no money, right? So there's a cost order against them, and they have no money, and they have no money, so they just don't pay. So what happens then? Like, they, do their pleadings get struck out? Do they, like, what happens? Because if they can't pay, they can't pay. So does the whole lawsuit stall? Like,
no, there is an order for costs outstanding against that party. It will
right?
get registered. It can be reported to a credit bureau. It will
Okay,
be hanging against the person forever. A person
I
can be garnished for
see.
cost order if they file income tax returns. Quite often where you see this
I
the
see.
most is where, let's say you have a gentleman, sorry, this is probably sexist, but where you have the gentleman who the family is broken down, kids are with mom,
Right,
dad absolutely refuses to pay child support, he won't produce a financial statement, he won't produce his income tax returns. An order for support is made against him,
right.
and it's based on imputed income because the guy has just not participated at all, has not paid, has not filed any documents to support his own position. The court makes an order for support against him
Yeah.
and also makes an order for costs.
Okay.
That if the court finds that the costs were incurred by the successful party for the purposes of obtaining a support order, the costs order is enforceable by furrow, just the same as if it was
Okay.
support. So it gets added to a statement of arrears. So it's more, so the person is just digging themselves into a deeper hole that they're owing all this money. So it does make a difference. Again, somebody may just shrug and say, well, I don't care. You can make all the orders for costs against me that you want. I'm judgment proof.
Right, right.
Which they could do, but again, if any of the cost order against a person is because of a support order that's being made, that part is not declarable in bankruptcy. It doesn't get wiped out by bankruptcy.
Interesting.
And again, for somebody that acts in that way, that says, I'm broke and I can't afford to do anything, costs are only one of the tools or weapons in the arsenal that a court can have against an unreasonable litigant. The other things, like you mentioned before, like in addition to there being the option of making a costs order or not, the court can make an order to strike pleadings.
Mhm.
They can order that the person not be allowed to participate any further in the trial. So there are a number of different things it can do. It's not necessarily that a failure to pay costs means that you're not going to be allowed to do anything else. Now, where it does come in though, is let's say that you just decide you're not going to participate, you're not producing what you need to do, a case goes to an uncontested hearing against you, your
Mhm.
partner has the children living with him or her, they get an order for support against you, you have not filed any disclosure or anything else. You've got an imputed income against you, so there is a support order against you, and 3 years down the road, Fro is starting to come after you, and you say, I need to bring a motion to change. Again, under the rules, that is a very strong argument for not allowing a motion to change to proceed if there's an unpaid order for costs.
Oh, interesting. Okay, okay.
So that would be one of the first things that the party that got the order for costs would say is this person is coming to court not with clean hands, because they
Interesting.
have not paid the costs award. And there are court judgments out there that have said if somebody is looking at bringing a motion to change because they were a jerk during the original court proceedings,
Right.
guess what? You can't proceed with your motion to change until you pay the costs orders that are outstanding.
Okay.
So there are different things that a court can do to put some teeth into a costs order. And again, just the fact that you are income impecunious does not mean that a court will not make an order for support against you. It is something the court will consider. Usually where you see a case where a court won't order costs where they otherwise would have is maybe with a situation where you have a parent who has children in his or her care, and an order for costs would severely impact that parent's ability to financially support the children in his or her care.
Right.
But again,
Mm.
that's one of the outliers out there. It's something that you really have to get a strong evidentiary background to try to support.
Got it.
Okay,
Okay, sounds good. Right.
so does that make sense?
Yes, no, it's good because I always worry about costs, orders not having teeth. I think that was what I was trying to get at. Yeah.
One of the best things are that I think really, really works
Mhm.
well is even if you have no expectation that a person is going to pay a costs order. It just means that if they ever try to drag you back to court on a motion to change,
Yeah.
that's one of your first lines of defense, is saying
Wow.
you got to come to court with clean hands. There's an outstanding order.
That's
It's never
good.
been appealed. This person should pay up the costs before they're allowed to take a run at changing the order.
Yeah, that's good. Whew. Okay. Okay, go ahead. Right.
Okay, so again, we've talked about this whole thing about the myth about if a court orders that the other side has to pay your costs. That means, like, for example, if you have a lawyer, that you just present your lawyer's bill and the other side will be ordered to pay that exact amount.
Yeah.
Full recovery costs, as I said, is very, very rare.
Right.
But Rule 24 sub 8 does say that if a party has acted in bad faith, the court can set the other party's costs on a full recovery basis, which means whatever the bill of costs says, like if it's a lawyer's bill or whatever else with all the disbursements and everything else that's attached in it, if the court finds that a person has acted in bad faith, they can order costs on a full recovery basis and they can order those costs to be paid immediately.
Mm.
Again, this happens really, really rarely.
Mm.
Courts are very cautious about finding bad faith
Mm.
because it really is a pretty dramatic ultimate measure.
Mm.
Trying to prove that the other side has acted in bad faith is a high legal threshold.
Mhm.
Like there's a lot of case law on what constitutes bad faith and what actually how bad does your behavior or actions have to be in order to hit that qualification of bad faith?
Yeah.
Because it just may be, honestly, if you're self-represented and you just don't know and you think what you're doing is the right thing to do because your uncle told you to do it,
Yeah.
then is that bad faith?
Yeah.
No, it's
Yeah.
not. Bad faith usually means that the court finds that you've done something that you know is wrong, that you shouldn't have done. So like I said, it's a very, very high threshold to meet.
Right.
So again, usually the advice that I give out all the time when I have people calling in as an advice lawyer saying, well, I think the other side acted in bad faith and I want to make an order, I want to ask for costs, but they're not agreeing, then I have to argue this. And I'm saying, well, you really should maybe talk to a lawyer that you're paying some money to, because trying to meet that high threshold of what exactly is bad faith is a really, really hard thing to meet.
Right.